There's a draft bill that's circulating in New York right now that would make tech companies' favorite argument invalid. The idea that a contract that you signed years ago would still cover AI training that's going on today. And the case that artists are making is that you can't consent to something that didn't exist at the time of signing. And now they're trying to make that into law. So here's how it started. There's an artist named Lauren Brantz, and she created a character called Cuppy for the Good Advice cupcake. She owned it, she created it. And then she found out that it was being replicated by AI based on contract language that she signed years ago that was never even meant to cover any of this. This sparked a push for the proposed bill called the Creativity Protection Act. And the idea behind it is real simple and clean. That any standard boilerplate language that's in contracts signed prior to generative AI, so phrases such as hereafter devised or all derivative work, cannot be used to give a company authorization to use a creative's work to train AI. And generative AI was not around before 2022. So the argument is that any contract signed before then cannot be informed consent on something that did not exist. To be clear, this bill is a draft. It has not been passed, but it is gaining momentum. And the principle behind it is already grounded in New York contract law. So we see what this principle does. Tech companies that are defending this AI lawsuit are leaning on one main argument, that you already agreed to this. From the terms that you already agreed to, from the licensing that you already granted, from the hereafter devised language that's in the contract that the publisher gave you 15 years ago, you already consented. But this proposed bill cuts all of that off at the root. If the use cannot be foreseen at the time of signing, then your signature can't be used to cover it. If a company wants to use your work to train AI, they need to come back to you, explain what it's for, and negotiate a new deal with fair terms. You keep your copyright. You keep everything that you already have. But AI is a fresh conversation that needs to be carved out that has fresh consent. And this principle is bigger than just one bill. New York City contract law already recognizes that you can't be bound to something that was not imagined at the time of signing. What this bill does is makes it specific, explicit, and enforceable during this AI era. So whether this bill passes or not, and there is a good chance that it will because there is federal pressure pushing back on state AI laws, the principle behind it can still be followed today. Pull out the contracts that you sign with your publisher, your label, your distributor, or your platforms. Look for language that says all derivative work, or hereafter devised, or any technology now known or later developed. This is the exact boilerplate language that tech companies are using to walk through the door. And now you know what to ask. Does this cover AI? And if the contract is old enough, the argument is that it doesn't. And if you're signing something new, push explicitly for AI carve-out, a line that states that AI does not cover this and it will require a new agreement. Artists that understand the language in their old contracts will be positioned better when this fight lands. Because when this fight lands, it will land on independent artists and mainstream artists. So real question, do any of your existing contracts have hereafter devised or all derivative work language in them? Or have you never looked? Tell me below.